A prosecutor basically is called a minister of justice. So as a prosecutor, you're there in court to see that justice is done. You're not there to get a conviction at all costs. You have your role is more similar to that of the judge than it is to that of a defence counsel. A defence counsel is there to try their best within the restrictions of the law and professional ethics to get his or her client acquitted. A prosecutor is there, like the judge, to see that justice is done between the opposing parties. At the same time, the prosecutor has an obligation representing the community to present the evidence in the best light and to present it in a way at its highest. So to advance arguments that are going to be cogent and appealing and persuasive. So in a way it's a little bit of a schizophrenic role, because you're there as a Minister of Justice, so one of your important roles is to ensure that the accused gets a fair trial. But you're also there to make sure that the community gets a fair trial. And to present the evidence at its highest. And sometimes the path of negotiating those dual objectives can be quite a difficult path to weave. What has changed are some of the obligations, like the duty of disclosure. I think now, as a prosecutor, your obligation to disclose to the defence is basically almost everything that you have, the defence are entitled to have. Everything that you know, the defence are entitled to know. There are one or two minor exceptions, like if there's if somebody's life is going to be at risk, if you disclose their identity, then you're entitled to not disclose their identity, again subject to certain exceptions. If there's an ongoing police investigation, then your obligation is to enable the police to complete that investigation before disclosure. But by the time of a trial, the accused is entitled to know everything that may be relevant to the defence case. It might assist your case, it might assist the defence case. Your obligation is to disclose, so that the defence is in exactly the same position of knowing as much as you know. And I think that that duty of disclosure has become heightened since 1920. And part of one's role as a prosecutor is to explain those legal concepts to jurors in a way that they will understand, and to adapt the facts to something like self-defence. And I think it's really important for a prosecutor to be able to explain those concepts to ordinary people in a jury trial who are listening to the evidence, and so that they can then use those concepts, look at the facts that have emerged in the evidence, and then come to a decision. And the presumption of innocence is basically this, that the prosecution brings the charge against the accused, and for that reason the prosecution has the burden of proving that charge. The standard of proof that's required is proof beyond a reasonable doubt, which of course is a very high standard. And I'll come back a little bit later to consider those words beyond a reasonable doubt, because they've caused no end of anguish to prosecutors, defenders and judges. The standard of proof. For hundreds and hundreds of years now, we've used the term beyond a reasonable doubt. And the appeal courts have said many, many times, judges and lawyers should not define the meaning of those words. It should be up to the jury to interpret those words and apply them to the facts of each individual case. So what judges say to juries is, I cannot tell you what those words mean. Beyond means beyond, reasonable means reasonable, and doubt means doubt. And I can't tell you how many cases I've had where the jury have come back with a question once they've retired to consider their verdict, and have said to the judge, we want some help in defining the standard of proof that's required for beyond a reasonable doubt. So to my way of thinking, it's just not enough for judges to say to juries, I can't tell you what it means, you've got to say what it means. Let me explain to you perhaps why juries have that difficulty. We're in an office building here. This office building I think has probably been here for 30 years now. It's a very solid building. If I was to say to you, are you certain that when you come to work tomorrow that this building will still be here, what would you say? There might be an earthquake, there might be nuclear war overnight and the building gets hit by a nuclear weapon, there might be some terrible fault in the building and it collapses unexpectedly. Yeah, there are any number of possibilities, what I would loosely call pigs might fly possibilities, of what might happen to this building so it's not here tomorrow. But are you satisfied beyond a reasonable doubt that the building will be here tomorrow? Beyond a reasonable doubt. So you've dismissed what could loosely be called fanciful possibilities or pigs might fly possibilities, and you've administered a test of your reasonable doubt and you're satisfied that this building will be here tomorrow. Correct? Okay. Now, what that demonstrates to you is the difference between mathematical certainty or scientific certainty and beyond a reasonable doubt. You're using your common sense, you're using your knowledge of building structure, you're using your knowledge of the state of the world today, that there's unlikely to be a nuclear war overnight, you're using your knowledge of the geological stability of the eastern seaboard of Australia, that there's highly unlikely to be an earthquake, although earthquakes do happen. There was a nasty one in Newcastle some years ago, but it's unlikely that tonight there will be an earthquake and this building will collapse. So you're using all of that knowledge of the world, you're using your common sense to come to a decision that beyond a reasonable doubt you are satisfied that this building will be here tomorrow, even though it can't be proven to the point of mathematical certainty or scientific certainty. Now,